discussion. We have an interesting panel today. We will be discussing the content for digital media, and we have a very distinguished panel with us today. We have Brinda Ben, an independent legal practitioner working in the Supreme Court, with Udbhav Tiwari, public policy advisor, and Mr. Brijesh Singh, Inspector General, Government of Maharashtra. And to moderate the discussion, we have with us today Aditya, journalist at Media Nama. Over to you now, Aditya.
Thank you so much. So, thanks to everyone that's talking right now. We have sort of a loaded agenda right now. We are going to be perhaps exploring some of the most contentious debates of our time, and we will try to cover as much as we can because we do just have 45 minutes. We'll try to touch upon content takedowns, moderation, encryption, and the general implications of these debates on privacy and freedom of speech. So we'll start with encryption, or rather more specifically end-to-end encryption. So Rinda, I'll start with you perhaps. Just for context, I mean, for anyone watching, law enforcement agencies have traditionally argued for encryption and argued against encryption, and since they believe it hampers investigation because the originator of the message cannot be traced down. So Rinda, should there be backdoors, and is there any law or judgments that allow or disallow backdoors? So if you could tell us a little bit.
Yeah, thanks a lot, Aditya. I mean, I think one thing to kind of clarify from just understanding the law enforcement perspective is not that they are against encryption per se. What they often want, because I think there is a understanding that encryption does provide safety and security, which is beneficial even in that sense for law enforcement. I think the demand is access to plain text information. So the demand often is to have a backdoor to an end-to-end encryption. So it's not against encryption per se. I think the concerns are with default end-to-end encryption or creating a backdoor for encryption. And I mean, so your first question relates to, should there be a backdoor? And I think, and so again, like the law enforcement perspective is, it's just a backdoor in one particular mobile phone. We're not asking for backdoors to be made, in all phones. And I think the reason that argument doesn't work and why I believe we should not have backdoors is primarily because of the privacy and the security concerns it raises. So first on privacy, first maybe let's go on the security concerns. The debate on encryption is often framed as a privacy versus security debate, right? So it's the privacy of users versus law enforcement security purposes. But I think it may help to reframe the debate and think of it as a security versus security debate. So it's not just a question of law enforcement or national security, but it is also a question of user security. So when you create a backdoor, even if the backdoor is just in one iPhone or one phone, what you are doing is you are in some sense changing the platform architecture. You're intentionally creating a vulnerability, right? And what happens when you create a vulnerability is you're increasing the system complexity. There are unanticipated vulnerabilities. You can't have a backdoor only for law enforcement. Once you create a backdoor, it can be a backdoor that can easily be exploited by third parties or bad actors as well. So it's not possible to have a hypothetical backdoor that will only be accessed by law enforcement agencies. And I think that's one reason that we should realize that there are security implications as well for all users when backdoors are created. The second issue, even when it comes to security perspective, is that a lot of the way, some of the means to break end-to-end encryption, things like ghost protocols, if you add another user, another end to the conversation, etc., or if some softwares are provided during an update, which may create a vulnerability. What all of this does is makes users more suspicious about any vulnerabilities that may be added through software updates. So what you may also see is that people will be less willing to update their softwares because they believe that certain kinds of vulnerabilities may be introduced through a software update. And all of that, again, will undermine user security because software updates are meant to, catch bugs, etc. So that's from a security perspective. Again, obviously, going to a privacy perspective, I think the main idea in terms of privacy is when you create a backdoor, and we must realize we are living right now in a system where there is no judicial oversight over law enforcement actions. It is completely executive oversight, right? So there is a tendency that it could be misused. And in certain cases, we have seen that the number of interception orders, for instance, may be misused. So I think what all of that leads is that people get very worried about what are the things that they may be speaking about, that may be recorded, that may be, end-to-end encryption may not be secure. And there is then a chilling effect on free speech. There is, apart from just a chilling effect, the idea is that a private thought expressed in confidence over a chat app is an extension of my personal identity. And that deserves protection from unwarranted government access. And so both, and maybe we can get into this later, but this whole idea that, only terrorists have something to hide, and if you have nothing to hide, you should not be worried, is actually not true. The I have nothing to hide argument has really effectively been debunked everywhere because, of course, it's not just about having something to hide. So I think both from a privacy and a security perspective, there shouldn't be backdoors. That doesn't mean that there are not other alternatives for the government. There are actually a lot of alternatives, and maybe we can get into that in the second round of questions. Sorry, what was your second question? Or should I deal with that later? You're on mute, Aditya.
Yeah, it is malfunctioning. So are there any, is there laws or prior judgments, court judgments that, allow or disallow the use of backdoors? And what do you think about the argument of backdoors being, a reasonable restriction on freedom of speech? Throw some light.
I think we would have to evaluate that from a Puttaswamy standard. There is not any judgment that would, I think per se answers the point. I think what we need is to have a proportionality analysis. So the question is not just, is it a reasonable restriction on speech? It's also, is it a proportionate restriction? So the requirements are, it has to be backed by law. So it cannot be by executive notification or a government order. There has to be a legislative basis for creation of any backdoors. Second, there has to be a legitimate aim, which I think in this case, of course, there would be a legitimate aim. The third, and the most important, probably the element of the test, is that there has to be no other alternative. So this is the least restrictive alternative that has to be demonstrated to be able to achieve the means. And there is no suitable, equally efficacious alternative. And I think this is something where I believe there are alternatives. And the fourth is, which is again an important element, what is the impact or the disproportionate impact on the rights of citizens versus, the government aim? So you actually have to have a balancing of rights. So public order versus, say, privacy rights or security concerns, and that has to be balanced. I have argued elsewhere in an academic article that what the Aadhaar judgment demonstrates is that we do need judicial oversight of surveillance action. And so I do believe that if backdoors are, do have to pass any test of proportionality, they would have to pass, they would require judicial oversight at the very minimum. But I think then on facts, we would have to have an analysis of does it meet the Puttaswamy standard? And I think at this stage, it doesn't.
Okay. Thanks, Linda. So, Uddhav, if we could come to you, India has sort of taken a stand on this, on the use of backdoors, because it has, I think, signed a statement calling for backdoors along with the Five Eyes nations. So, why could you spell that out a little bit for us? Why India had signed that statement, and could throw a little bit of light for us on that.
Sure. Thanks, Aditya. I think it's important to note that India isn't operating in a vacuum, right? Many of the concerns that law enforcement agencies have raised in India have also been raised elsewhere in the world by law enforcement agencies for getting access to encrypted communications. And the context for end-to-end encryption in many ways also extends beyond the messaging debate. For example, there are online platforms like Tor and other forms of encryption that also make it difficult for law enforcement agencies to carry out investigations. So I think that the reason India signed that statement and has also signed similar statements in the past is because of solidarity. It wants there to be collective pressure on online platforms in order to make sure that these considerations are taken into account when products are being designed. However, I do think it's, like Rinda pointed out, it's worth poking a little bit on the question of like how much will having backdoors on encrypted communications actually benefit law enforcement agencies, and also how much will it make their jobs harder. And the primary reason it will make their jobs harder is because a vulnerability that exists for you is also a vulnerability that exists for anyone else who's looking to exploit that system, right? Like, so because of the fundamental technologies around end-to-end encryption are very, very common and are almost ubiquitously used across many platforms all over the world. So to introduce such a vulnerability will almost necessarily require the weakening of such systems in a manner where their after effects may be felt far beyond just common users and for mass surveillance purposes. For example, if that same protocol or that same standard is being used by government agencies or is being used by the armed forces of a nation, then it actually increases the risk of their communications being intercepted as well because of the fact that these backdoors were necessarily baked in. Which is why I think that it's definitely very important that law enforcement, like, I don't think anyone will say that the concerns that the law enforcement agencies have are illegitimate. They're definitely very legitimate concerns, right? Like, I mean, in order to be able to conduct investigations on time. But there are far more systemic and procedural reforms that need to take place between how countries share data with each other, the sort of oversight that these powers have so that these decisions can be made quickly and in a broadly reliable manner. And we've seen some of these measures. For example, in the United States of America, there is now a law called the Cloud Act that actually allows technology companies from the United States to directly share information with third-party governments once they have undergone a process. And the United Kingdom has already been certified under this act, and it's quite likely expected that Australia is going to be the next country that is certified under this act. So to say, if this were to take place, there is an incredible amount of metadata that is already available to law enforcement agencies and full-fledged data as well from other communication services, that instead of the months and sometimes years it currently takes, will take a far lesser time to reach them and will be able to allow them to conduct investigations in a far more reliable manner. So I think it's very important that whenever we speak about end-to-end encryption, we also speak about what are the other solutions that countries like India and other countries can carry out in order to actually address some of the legitimate concerns that law enforcement agencies have.
Thanks, Uddhav. I guess that sort of does. I mean, the fact that we have that the fact that India has signed this agreement sort of makes it clear, right, that traceability is what the ultimate aim is, right, and that could eventually lead to the strengthening of the argument against for backdoors, right? Is that a good read of the subject?
I mean, I would say that it's hard to say that they are specifically pushing for the backdoor in that letter, for example, because all it actually says is enabling means to address concerns that law enforcement agencies have. I would say that backdoors is one and probably the most commonly debated one, but many of the other, like for example, metadata and things like that we have spoken about are also alternative ways that actually allow many of these concerns to be addressed. Just to give you an example, both WhatsApp and Signal are end-to-end encrypted platforms. But the amount of metadata that is available on WhatsApp is much greater than the metadata that is available on Signal, right? So if this is about making other providers collect more metadata or make sure that this metadata is more easily available to law enforcement agencies, those would also actually go a fair way in addressing those concerns. So does it explicitly support the idea of a backdoor? No. But is a backdoor one of the solutions that they have proposed in the past with similar language? I would say yes. And I think it's a worthwhile endeavor to sort of like discuss that a little more and see if there are better ways of achieving a similar outcome.
Thanks, Uddhav. Thanks. Mr. Singh, if I could, I wanted to come to you last because I wanted your take on this whole backdoor issue and encryption. So, what is your take? What do you think, Mr. Singh? Are backdoors? Do you want, as law enforcement, do you want backdoors, and will they help your investigations?
I think the question has been framed wrongly. It's not about backdoor. It's about law enforcement having reasonable access to information which is essential for investigation. See, law enforcement has a lawful purpose. Law enforcement has a bounden duty to protect its citizen. It has a duty to protect the rights of victim. And whatever access law enforcement has is by a due process of law, where there is transparency, there is audit trail, and there is accountability. So, in fact, if you want to turn the encryption debate on its head, you can use the same arguments which are used against backdoors for encryption. You are saying that a backdoor can be potentially misused. Here you have a case where encryption is being misused by drug traffickers, by people who are indulging in child porn, by human traffickers, by terrorists. So let's not go to a moral argument that a backdoor would be misused by terrorists. Here it is being misused. So if you apply the same argument, then don't have encryption, right? But we understand that encryption, even for law enforcement, even for the state, even for military, even for intelligence, even for individuals, is essential. The question is not of encryption or not encryption, or backdoor or not backdoor. The question is of a lawful access to data, information, evidence required for investigation. Now, how you want to provide it? You cannot invent an invisibility cloak and then go on murdering people and then say, no, this is for my privacy. So then again, it's a question of a reasonable access, where everything that you require, that right from the due process to accountability, everything is there. See, it's like the COVID vaccine, that it is essential, but it's not a perfect solution. And there are going to be, at some places, stray instances where people would react strangely to it. But does that mean that we throw away the baby with the bathwater? No, we don't do that. So wherever we are using something, we have to understand what is the ultimate use of it. In the sense that, look at the ultimate impact. If you say that, let's say, law enforcement has at times misused provisions of interception, but that doesn't mean that all interception should be stopped. Now, if you just ask any agency and ask them how many phones are lying with them which cannot be opened just because there is encryption on it, how many murders are unsolved, how many missing persons are out there which cannot be traced just because there is encryption. So our argument is not about backdoor. Our argument is about getting to help the victim. Our argument is to further the ends of justice. And if anybody has problems with that, I think it's a serious problem. But you cannot every time come back and question the basic principles that, oh, I don't believe the executive, oh, I don't believe the government, oh, I don't. So that I think is a very flawed argument. And just because something can be potentially misused, so you see that it is being used. So somewhere I think that we need to build a robust process, and with a robust process, you should have a mechanism where you get reasonable access to law enforcement for investigation and for gathering evidence.
Mr. Singh, I do think that, anybody who's read a little bit about the subject, or anybody who's observed this, I'm sure they would agree with you that there is a legitimate purpose that law enforcement do need data to investigate. However, I think Vrinda had put it well earlier in the discussion that you can't have backdoors that can only be used by law enforcement. So, what do you think about that particular nuance of it? Because if there are backdoors, of course, law enforcement would be able to use them. But what about people who will probably misuse it? I think that is rather the more important debate.
I told you the same thing, argument which applies to a backdoor applies to. If you're talking about misuse argument, then more than backdoors, encryption is being misused. So the argument does not stand. I again told you that the argument is about lawful access. When I say lawful access, I want to say that this is for a purpose of even maintaining, solving crimes, justice to victims. So, backdoor or no backdoor, the basic question is of having access to data for these lawful purposes. And backdoor is something which companies now, these commercial companies, they don't want to part with any data. In fact, we should look at corporate surveillance. Corporate surveillance is the biggest problem. Right now, if you just log on to, a site called infobleed.com, which a friend of mine, Rohit Srivastava, has made, there are parameters going from and who all making use of this information. There are no governments who are making use of this information. It is which is a much more serious issue today, and they are making a commodity out of you. They are today become an arbitrator with quasi-judicial powers. If you want to restrict freedom of speech, there is a lawful method. Only, the state or the executive, due process of law, has the right. Today, these companies arbiter of free speech and deciding what is free speech or not. So it's a situation where I think big tech should not getting into the shoes of nation states and address the larger question, not these technological impediments that encryption has come. Encryption, if backdoor, will create a privacy problem. You are the biggest looter of privacy. Big tech is the biggest looter of privacy. Where are they talking about privacy of the citizen? Yeah, please continue.
So, one last question before we restart the round. How useful is metadata in your experience for investigations? And what do you think about alternative mechanisms that perhaps in that processes have they been effective in your work so far?
Even if you get metadata is going to give you circumstantial evidence. But to get concrete evidence, you will still require that communication, that message, right? That transaction. If that is not available, what evidence would you produce before court of law? So metadata is essential, but it is still a secondary chain of evidence, and it is a very weak kind of evidence. Though I understand that metadata does give me, location, it gives me which actors are there. And if I look at investigation, then I can look at why this actor did this particular action at this time, so on and so forth. Metadata is very good. MLATs, I think, have limited time for MLAT today to respond is in probably years. We are not getting any real-time responses with MLATs. So I feel that MLAT is a flawed methodology. Also, the Budapest Convention, if India has not signed it, then that creates problems in getting data from other countries. But see, these things are loaded, right? So in Budapest Convention, if it is just about sharing of data, it's okay. Then they want to define for you how democracy is. Then they want to define for you under the guise of a technology law. Then they want to sort of impose their ideologies here, which again is, I think, not proper. So somewhere we'll have to come up with a real-time mechanism where we share data. See, like US has a singular access with Cloud Act. If it's a US company, they can get data which is residing in any country. But today, if you want to, ask for data to any of these platforms, they say that your country's sovereignty is subject to my company policy. It's a very anomalous situation which needs to be dealt with immediately. Aditya?
Thanks, Mr. Singh. We got the Singh's version of the debate. So if you could tell the lawyer's version of it, what do you think law enforcement should do, and what do you think they should realistically aim for that is mutually agreeable to civil society as law enforcement themselves?
Sorry, is that a question for me or Udbhav? I missed the first part.
Yeah. For you, Vrinda. For you.
Oh, okay. I think in the context of, there are one or two points that I'd like to clarify, right? I don't think anyone is saying that the corporates here are fantastic and like beacons of transparency and we must listen to them, right? I think corporate surveillance is a huge issue and it's something both Udbhav and I have spoken about, for instance, at various other platforms. The reason one is always a bit more concerned with government surveillance or government powers is also because at the end of the day, the government has the power of law behind them and has the power. Hence, there is a monopoly of violence which government always has, right? The ability to lock you up, the ability to imprison you. So that is the reason one is always more concerned, because of the centralized nature of government power. One is more concerned about government power than corporate power. None of which is to say that corporate surveillance or the actions of corporates should not be subject to a lot of debate. And I think, we are having those debates. So that's just kind of one thing, which is that no one is keeping the corporates off the hook. The second, I think, like even in terms of what Mr. Singh said, I am not exactly sure, and I do not necessarily agree that we have the requisite amount of transparency or accountability in the functioning of, law enforcement agencies and requests for interception, right? A lot of this debate, a lot of this information, and I think Media Nama has sent RTIs, right, about interception requests, which have now been rejected under Section 8 or Section 24, even though SFLC had received responses, I think, in 2014 or 11. And what that SFLC response had indicated, which we even saw in the Justice Sri Krishna report, is that the number of interception requests is in the thousands, right? And so we know that there cannot be any due process of mind, because if every 2 months a law enforcement agency has to go, the oversight committee has to review 8,000 requests or 4,000 requests, you cannot apply your mind on each and every request. So now we are seeing, and I mean, you can correct me, but my memory is that Media Nama has sent certain RTI requests with respect to interception, and they were rejected, right? So, I mean, you're not seeing that information either proactively or in response to RTIs, right? And this is a fairly innocuous question. All you're asking is how many surveillance requests were put in under Section 69 of the IT Act. You're not asking for details of individual requests. You're asking for aggregate figures. I know ISS has also asked similar requests, and I think they've been denied as well. Second, so you don't see proactive information coming from government. You don't see it in response to RTIs. We also have a situation, as Justice Sri Krishna himself has pointed out, where our law enforcement agencies don't have either, are not necessarily subject either to parliamentary oversight or to judicial oversight. You don't have a lot of, the statutory basis, etc. The accountability core parliament is also not there with many enforcement agencies, and nor are they subject to court orders, in the sense of before having any interception order, you do not need the authority of court, right? So there is no judicial oversight over each action. And I think because of those reasons, it's not just a question of, there is no trust in government or anything like that. I think the idea is, what are the due process structures in place that will give me confidence as a citizen that those powers are being used properly, that those powers are not being misused. And I think that is kind of where I fundamentally disagree in terms of the checks and balances in place. And I think that's why we need a reform of, intelligence laws in the country. And I think Puttaswamy is the first starting point, and it will result in, more and more, hopefully, like streamlining of operations, proper oversight and accountability mechanisms. And I think the final thing is also to say that, I do think metadata gives a lot of information. When you combine it with the other parts of, in terms of tracking conversations, so interception, the abilities under Section 69, which are fairly wide, which also includes some ideas of decryption, etc. So when you look at that, when you look at how much, metadata may tell you who is in contact with whom, how many times, device information, location information. Of course, it doesn't give you the content of the conversation. But in many cases, you have situations where these chats are backed up. So, you get access through those. Udbhav himself, maybe he'll speak about it, had taught me this idea of weakness by design, which maybe kind of he's best placed to speak about, which is that in many cases, even the tech companies are not going all the way around, because they realize there are these law enforcement concerns. So they're not introducing default end-to-end encryption, for instance, in Facebook Messenger, which was initially mooted. The fact that Google Drive backups of WhatsApp conversations are not end-to-end encrypted is another factor, right? So it's like there are these other alternatives. I also think we would need some kind of facts and figures as to in how many cases was end-to-end encryption an actual impediment in the ability to get the conversation? We know there are alternatives that agencies have, right? We saw this in the US, even in the Apple FBI debate. Once Apple refused FBI the information, FBI was able to get some software from some third-party spyware agency and was able to crack the code. So there are these alternatives that exist, and in fact, in the US, it is legalized. Like there is a vulnerabilities equities process, and that may be again an interesting route of conversation, which is that do you have some sort of regulation over these other abilities where we all know security agencies and law enforcement agencies have the ability to break end-to-end encryption conversations today. But maybe it's time to sort of have a discussion around that and how that may be regulated in a legal framework.
Thanks. I think now is a good time to segue into the second subject that we wanted to explore. And Uddhav, if we could come to you. Speaking of non-personal messaging, we have spoken about personal messaging and encryption so far, and we also have a lot of censoring in terms of content takedowns of content like child pornography, for that matter, or anything for that matter. And again, speaking of the same theme that Rinda had just brought up about there not being enough transparency. So could you tell us a little bit about how the content moderation scene is going on right now, and how there is a lot of new technology that's being deployed? For instance, I think Jio and Airtel are using middle boxes or server name indication inspection to track down websites and block them. So there is no transparency. Honestly, we just don't know who's doing what and what is being blocked. So could you tell us your thoughts about the need for transparency and what you think about this? Uddhav.
Thank you, Aditya. I think that there are like 2 or 3 broad ways in looking at this question, right? Like the first is, how is content that needs to be blocked decided in the first place? Within the IT Act in India, there's actually a procedure that's already established where there's a committee that sits out of the central government that does sort of decide what content it wants blocked and what content it doesn't want blocked. And these are the content blocking rules that I think date from 2008, 2009. And that process in and of itself is definitely something that needs to be much more transparent, right? Like the outcomes of what that committee decides, the amount of information available in the public domain about who members of that committee are, when meetings take place, are all really, really hard to come by. And in fact, the rules themselves say everything that happens in that committee is automatically confidential. So that's something that's the first bit, right? Like even the centralized mechanism that India does have for content blocking and content takedowns is nowhere close to as transparent to the public as it should be. And it doesn't really allow for an opportunity for sort of redressal, right? Like imagine if I disagree with the fact that a piece of that committee recommended a content that I want taken down. Like currently, it's not even clear if I can take it to court, and if I do take it to court, what the process will be, and how quickly will the committee be able to like react to whatever the court's decision will finally be. Apart from that, secondly, I think there's also like this very vast disaggregated array of ways in which content are blocked, right? Like for example, at a state level, at a city level, it's quite common to hear that there are not just law enforcement agencies, but other government departments that require content to be blocked and just order ISPs to do so. And sometimes these are some of the biggest websites on the internet, right? Like there's Reddit, there's a bunch of other big websites, there's GitHub that have simply been blocked for extended periods of time in India because of the fact that they were that this decentralized decision-making process wasn't really considered, because many of these websites actually offer ways of getting content to be taken down independent of blocking that whole website. Right? Like you can call the website, get in touch with them, explain why the content violates local law, and they're happy to sort of restrict it in most cases. And finally, I think there is what is taking place when there are measures that users use to overcome these sort of limitations, right? Like, and specifically the question that you asked about server name inspection. So usually website blocking in India is done at a DNS level, but as like is quite commonly known, ISPs also leverage this DNS information that they have about you and sometimes sell it to advertisers and use it to target you in different ways. So there are many people who are either using other DNS servers and not ones of their ISPs, or are encrypting their DNS communications, and which is why platforms like Airtel and platforms like Jio, and there's a comprehensive report from an organization called the UNI, which is the Open Network Interference Initiative, has analyzed how SNI blocking, which is a far more complex way of looking at which website you are connecting to over an HTTPS connection is now being used to block websites in India, which is not only not very reliable, but it's also something that we traditionally see take place in regimes like Iran and China and in other places. So I think like the cumulative summary of a lot of this is that it's very clear that content blocking, that there are legitimate reasons when content blocking should take place, and that there are procedures under Indian law, but the amount of transparency that should exist around that, because at the end of the day, it is also a form of encryption when you use HTTPS that is allowing for a lot of this information to exist in the first place. The requisite amount of public transparency, but also just how much discourse there is in law, right? Like, so for example, in the Shreya Singhal judgment, it was very clearly like the regime in India before this actually allowed anyone to issue takedown requests, right? Like if I got annoyed at a particular piece of content on the internet, I could write an email to Google, and I was empowered under the Indian IT Act for that content to be taken down unless the person who put it up challenged it back. And there was this very fascinating research that was done that when it was found out that when people sent these requests, the vast majority of them were actually being taken down without being evaluated. People just sent fake, like as the research was about sending fake requests, and so many ISPs just blocked those websites without even looking at whether the content was illegal or not. Like people said cooking recipes were annoying them, and ISPs ended up blocking like websites that had cooking recipes and so on and so forth, right? So I think that the amount of vetting that needs to take place for these requests, as well as like making sure that there is information available in the public domain. And by transparency, I don't think we necessarily mean that all this information should be available in one place. So nobody wants for there to be like one PDF with all the blocked websites in India available for anyone to utilize, because obviously there are lots of harms associated with that, and it will serve as a way of like a honeypot almost, where all like bad actors will be able to leverage that in whatever way they want. But I think there should be a middle ground where the government, the industry, and civil society work together to just make sure that there is a tangible oversight over this process in a manner that it addresses everyone's concerns.
Thanks, Uddhav. I think, Mr. Singh, if I could come to you next, there is, as Uddhav has just said, there is genuine need for transparency. I'll give you an example. As a journalist, I've tried to find out why a certain website has been blocked, but the thing is, it's virtually impossible for someone like me to find out, because, for instance, some subreddits on the website Reddit are actually blocked, and nobody really knows who blocked them. So, could you tell us about why there is this the opacity of the system, and what is the justification behind it, and what do you think about it, and how things be improved in that regard, Mr. Singh?
There should not be any opacity. So there is no justification at all. I believe that there should be a transparent system. But see, sometimes there are reasons which are not apparent, which may be, let's say, about investigation. That if I give you away something which I'm doing, then it may aid the criminal, and it may abet the criminal in destroying evidence or running away or perpetrating crime. So sometimes there are things which cannot be told on paper, for which you may find that it is an impediment to transparency. But I believe that otherwise there should be absolute transparency. That there is no reason that there should be opacity. There should be transparency. There should be oversight.
No, I understand, Mr. Singh. I mean, if a certain act of blocking a website or anything else is important for any other legal purpose, obviously the secrecy perhaps needs to be maintained. But I'm talking about things like, for instance, the New York Times website had been blocked multiple times in the last few months and restored almost like a day after. Several ISPs have actually done this. So there needs to be some sort of a mechanism. States and the central government should perhaps be a little more transparent about who is blocking. And a little bit of transparency will help, right? I mean, we cannot with regard to investigation and in relation to investigation, right?
Yeah. Your voice was cracking. I couldn't hear it, but I believe that there are avenues for appeal against any blocking order, and whosoever is aggrieved has a right to appeal. Similarly, about RTI, there are levels of appeal where you can go up to the Information Commissioner, and there are very strict fines, and you can access information. Having said that, there would be at times, instances where it has the blocking orders are either inappropriate or incorrect or do not have proper justifications. But let me tell you that this all is actually weeded out at much before any blocking orders are issued. So sometimes we actually find that it is difficult to get anything blocked. So lots of our requests, they do not go through because after the Shreya Singhal judgment, it has left a hole in this whole jurisprudence, where there are things which need to be taken care of, but they cannot be because there is no law to deal with that. Similarly, the purposes of blocking have been very narrowly defined. So at times it becomes very, very difficult to actually get things blocked which should be blocked. So it's the other way around. And whatever requests are sent on behalf of law enforcement are actually to protect people and to maintain peace. And there is no other reason for that.
Thanks, Mr. Singh. I think we have time for one last question that I wanted to ask you. I believe recently in the last few months, sometime ago, you had said, you told a news channel, basically, I think this was during a busting of a child pornography racket, and you had remarked in that discussion that a lot of this content is taken down proactively, yes, by these platforms. However, it is never conveyed. The fact that this was ever up in the first place is never conveyed to law enforcement agencies or the government in general. How can that be improved, and what do you think about that sort of, again, lack of communication between the corporate industry, the industry and the government?
So that's what I'm saying, that whenever they are exercising any quasi-judicial function, then they do not have the right or justification to do that. They don't have a mandate to do anything like that. In fact, if you are destroying evidence, if you are destroying evidence which is essential for investigation, I think it's a crime. But they are doing it. If you are removing content, you should inform law enforcement. If it's a crime anywhere, if it's a crime in my jurisdiction, then though there is no mandatory reporting, but you should be informing us. And there are acts which have mandatory reporting, like Protection of Children from Sexual Offences Act, also has mandatory reporting. So if you are removing content and not telling anybody, then you are actually abetting crime. You should be telling this to law enforcement because there's a mandatory, reporting clause under the POCSO Act, but this is not happening. So you cannot, just violate the law of the land under the guise that we are platforms and we have immunity under 230C of Communications Decency Act of the USA. I think this is a very anomalous situation. Aditya.
Thank you. I believe we are up. If Brinda and Udhav, if you have any closing remarks that you would like to make briefly, either of you.
I'd just like to take 30 seconds to sort of talk a little more about the idea that Linda mentioned about a vulnerability equities process, right? Primarily because I think that in the case where if backdoors are not what we're going after, but there is obviously a legitimate reason for law enforcement agencies to have access to content, I think a vulnerability equities process is that middle ground, right, where governments can use means that are available at their disposal to get access to that content, but what vulnerabilities they exploit, the process that they follow for that exploitation, and what they can do with that information is also something that is, at the end of the day, regulated. Now, the Indian government has similar things internally with standard operating procedures in order to do a lot of this, but I think that talking about those procedures publicly and just making sure and having a public commitment on what vulnerability equities process is being followed will go a long way in helping increase user trust and general trust in the way that the system is currently operating. But that's my only suggestion. Thanks.
Thanks. Vrinda, if you wanted to say anything that you didn't get the time to, could you please?
Nothing. I think it's just kind of what Uddhav was saying and what I've mentioned before, which is that I think trust obviously cannot be demanded, right, from citizens. We just want to see some sort of proactive disclosure or some like elements of trust from the government that will allow us to trust them. So I basically think some elements of transparency will just go a long way. And so, you will have cases where, of course, website blocking is legitimate. I mean, I don't think we're saying this power should not exist. Like, that is not at all what either Udbhav or I are saying. These powers do exist, and, they should be used in kind of the least restrictive manner and the most narrowly tailored manner. But I think the problem becomes, when you just say no to everything, when you just kind of reject all requests, when you say, oh, I will not tell you why New York downloaded. And of course, that's a very different example from like a POCSO mandatory reporting example, right? And I think the problem is that the debate happens on this whole spectrum because you have these wide variety of examples. And so I think what is really needed is, I feel, an acknowledgement both from civil society that yes, there are legitimate demands of law enforcement, and then also of law enforcement, which is that yes, it is misused and we need better transparency. And I think that really is the only way forward.
Thank you, Vrinda. I believe we are out of time. I hope we had a little more time to explore these things in a little more detail. But thank you so much, Mr. Singh, Udbhav, and Vrinda. I believe it was nice speaking to all three of you.
Thank you.
Thank you very much. Thank you very much for the discussion. I see a lot of comments acknowledging how wonderful the content was. If I may request you to stay back if I can take a picture, if that's okay with you, the speakers.
Okay, how do I leave? Just a second.
I think Mr. Singh may have left anyway.
Yeah, Mr. Singh has just left. I'll leave. Goodbye.
Okay. I think Anand wants that. Okay. Anyway, Anand, I guess you should have left.
All right.